It's so good to be back at Rutgers. I grew up in Staten Island, New York, so this is sort of like going home, but it's the closest I'll get to home for now. I haven't been back to New York since March, and it makes me sad, but hopefully I'll be there soon enough. Thank you to my good friend Earl Maltz, who is a true gem. He provides such a good service to the school in so many different ways, and I'm always grateful when Earl is able to join us. Also, Earl is what I call an old school conservative. He follows a approach to judging that is not in vogue anymore. It's the sort of let's be restrained, right? Let's take a more moderate posture, and frankly, it's refreshing because a lot of people, myself included, aren't always very consistent on that point. The topic today is California v. Texas, which is the new challenge to the Affordable Care Act. I need to give a little history first to get there. In 2010, Congress enacted the Patient Protection and Affordable Care Act case, okay? I'm sorry, the Patient Protection and the Affordable, sorry, one second. Hey, Nick, would you mind putting this on record? I'm not sure if you started this one, but I just wanted to see if you could put that on.
Yes, I've got it recording.
Okay, great. Okay, thank you so much. In 2010, Congress enacted the Patient Protection and Affordable Care Act. This was an important law that tried to expand health insurance for many Americans. And perhaps the most well-known feature of the law was the protections for people who have certain pre-existing conditions. It's called Guaranteed Issue and Community Rating, GICR, Guaranteed Issue Community Rating. What this law says is that if you're sick, they can't charge you more money and they have to issue a policy. This is a very, very well-known feature of the law. But this feature creates a problem, right? What problem does it create? The problem that it creates is that people have incentives, right? If I know that I can buy insurance at any time and I can't be charged more for it, then maybe I'll decide not to buy insurance and I'll just wait till I get sick. And in several states that had experimented with guaranteed issue, you actually had people free riding. They would just not buy insurance and then they wait till they got sick and they bought a policy. This resulted in a skyrocketing set of premiums. In fact, New Jersey was one of those states. New Jersey required the insurance companies to cover sick people, and then premiums went through the roof. So there was a solution to address this. Massachusetts came up with it. Governor Romney was at the head. The government would mandate or require people to purchase health insurance. This was called the individual mandate. And if a person failed to purchase insurance, he would have to pay a penalty. And in theory, at least, this money would be spent to try to cover the costs of those who are uninsured, right? This penalty would help to defray the costs. All right, so Congress enacts a law that requires insurance companies to cover pre-existing conditions. And then Congress enacts a part of the law which says that people shall maintain insurance. It's commonly called the individual mandate, but that phrase appears nowhere in the statute. It's not called a mandate. All right, now fast forward a few years. A legal challenge is brought arguing that Congress lacks the power to require people to buy insurance. And in NFIB versus Sebelius, the Supreme Court, well, sort of agrees. The court says that Congress cannot make you buy insurance. That goes beyond Congress's commerce and taxing powers. But, and here's the big but, the law could be read another way. And Chief Justice Roberts introduced what he called a saving construction. A saving construction. Roberts says the best way of reading the statute is its mandate to buy insurance, right? That's the best reading of the statute. But courts have a duty, an obligation to read statutes in a different way. And if we look at this statute as a whole, we have these components. We have a requirement to buy insurance, and then we have this penalty for going uninsured. These are two separate parts of the law. But if we merge them, we fuse them together, the law looks a little bit different. We could perhaps read the law as imposing a tax on the uninsured. I said again, you have a mandate to buy insurance and you have a penalty for going uninsured. But if you fuse them, if you read them together, it looks different. You have a mandate ongoing, I'm sorry, you have a penalty, you have a tax ongoing uninsured. Roberts says Congress could tax the uninsured. That would be perfectly fine. And because the statute can be read in that fashion, then it will be upheld in that regard, right? But the key point is that's not the best reading of the statute. The best reading of the statute is that it's a mandate to buy insurance with a separate penalty. But this penalty raises revenue. You pay it to the IRS. It resembles a tax. If it walks like a duck, if it quacks like a duck, it's a duck, Robert says. It's not actually a tax, but it looks like a tax close enough. Okay, so that was in 2012. And that was a decision which I didn't like very much. I criticized heavily. I don't know where my friend Professor Maltz is in that case, but I thought it was a very strained reading of the statute. But Roberts did what he did. You know, the motto of Chief Justice Roberts is you cannot make any controversial decision within 2 years of an election. Right? That's his general operation, a mode to life. Earl's laughing. But we're gonna see this coming up in the next, I don't know, 20 odd days. Oh no, we're actually less. We're at 14 days now. My math is right. All right. Fast forward to 2017. Congress enacts the Tax Cuts and Jobs Act, or the Tax Cut and Jobs Act. This bill did a lot of things. It reduced different taxes. It gave different tax credits, which I'm not very concerned about. But there was one portion of the bill that's actually very relevant. There was one portion of the bill that said the penalty for going uninsured was reduced. It was reduced from about $700 per year down to $0 per year, right? So the penalty dropped from $700 to $0. Now you might ask, Josh, what's a penalty of $0? Is that the same thing as repealing the penalty? Not exactly, because in theory, Congress could elevate at any point. The statute remains. All that changed is that now $0 is added to your tax return. Okay. Fast forward now to 2018. Texas brings a lawsuit. And Texas argues, wait a minute. The John Roberts saving construction was dependent on the penalty resembling a tax. And the most important feature of a tax is it raises revenue, right? It raises revenue. The penalty in the ACA no longer raises revenue. Therefore, the argument goes, you no longer have a saving construction. And because the saving construction goes out the window, you're left with a mandate to purchase health insurance. And the court told us that Congress does not have the power to mandate the purchase of health insurance. Therefore, they say the mandate is unconstitutional. But wait, there's more, right? Texas doesn't stop there. Texas makes another argument. They say, well, if the mandate is unconstitutional, then other parts of the statute are also unconstitutional. For example, the guaranteed issuing community rating. When Congress enacted the ACA, they said that the mandate was essential to the guaranteed issue policies. You can't have these pre-existing condition protections if the mandate's gone. But Texas also doesn't stop there. They go yet further. They argue that the entire ACA, the entire statute, turns on the mandate. And without the mandate, the entire Obamacare law cannot stand. Therefore, Texas argues the entire law should be struck down from start to finish, from A to B, actually, or A to Z, as it were. This lawsuit was filed in 2018, and a federal district court in Texas agreed and said that the entire ACA is what's called inseparable. You cannot separate the mandate from the rest of the statute, and the entire statute must fall. The Fifth Circuit, it kind of affirmed, but not really. They said that the mandate was unconstitutional, and there might be other parts of the statute that are unconstitutional. But, and here comes the big but, you need to take a look more carefully at which provisions actually injure the plaintiffs. And so the Fifth Circuit didn't favor full invalidation. Okay. So now the case is before the Supreme Court, and arguments are scheduled for 18 days, so November 10th. So about a little bit less than 3 weeks from now. Why is the case California v. Texas? What does California have to do anything? Well, the Trump administration agrees that the mandate's unconstitutional. And the Trump administration agrees that at least some parts of the ACA have to fall. The Department of Justice doesn't favor the complete invalidation of the law, but they favor something close to it. So they're basically on the same side as Texas. The state of California and your beloved Attorney General Graywell has intervened, and they argue that we have history, Mr. Graywell and I, and they argue that the mandate is constitutional. So you actually have the state of California defending the statute, and the Department of Justice in the same side as Texas, which I don't know, Earl, that might last another 3 months or so. That might change in January. We'll see. Depending on what happens with the election, it's very likely DOJ flips on the other side and supports the ACA, which doesn't really change the case. The case is going to be in the same spot because California and Texas are arguing. It doesn't really even matter what DOJ thinks at this point. All right, so let's talk Turkey for a minute. When I filed a brief in this case in July on behalf of the Cato Institute, and we argue that the individual plaintiffs have standing. We argue that the mandate's unconstitutional. We do not support Texas in saying the entire law has to fall. We actually have a more targeted approach that said maybe certain parts of the law have to fall, but not the entire statute. But I'll be honest, when I filed this brief, I thought, okay, I know this one works. John Roberts is the fifth vote. He always breaks my heart. He's going to break my heart again, and he'll rule that the parties have no standing, or he'll rule that just the mandate's unconstitutional. But Johnny Boy ain't the fifth vote anymore. Her name is Amy. Or it will be in another 4 days or so, perhaps, right? So Judge Barrett's imminent confirmation, I think, gives his case a different flavor. But I still think, even with Judge Barrett on the bench, that Texas's relief is not going to work. They're not going to declare the entire statute unconstitutional. I think the most likely outcome is that the court simply says that the mandate's unconstitutional, but you can sever the mandate. And Judge Barrett sort of told us what she thinks. This is a weird wrinkle. She participated in a moot court a couple weeks before she was, or a couple days before she was nominated. And the moot court was based on the case of California versus Texas. And she actually pretended to be a Supreme Court justice deciding California v. Texas. Imagine that, right? A sitting circuit court judge judges a moot court on this case. And then she's nominated like 4 days later. Just who can write this? This is like Hollywood, right? So there's a non-trivial chance she'll have to recuse. She might have to recuse. I don't know. I think she doesn't have to, but this is a very personal judgment for every person to make. But in the moot court, Judge Barrett apparently, we don't have for sure, but apparently said that the mandate was unconstitutional, but you could sever from the rest of the statute. If she doesn't participate, you might even get a 4-4 split. As you all know, a 4-4 means you affirm the lower court, which would mean nothing really changes, but you go back down to the lower court to sort of consider this issue anew. All right, that's the legal argument. I want to talk about the politics for a bit. This is not a popular case among conservatives. In 2012, every single Republican, was behind the ACA challenge, right? Every single Republican wanted to kill Obamacare. It didn't work. In 2015, there was another Obamacare challenge. Fewer Republicans were keen on killing the statute. What happened? Look, like it or not, the statute has built what you might call reliance interests, as people have come to rely on Obamacare. For a certain segment of the population, it's been a positive. If you were sick, this is a good thing for you. If you were poor, this is a good thing for you. But for a lot of other people, it's not good for everyone. It's raised premiums. It's lowered the cost of the quality of coverage. It's had negative consequences for a lot of people. But politically, I think the Obamacare law has become something of a third rail. Think of Social Security Medicaid, Medicare, these sort of untouchable programs, right? The things that are just sort of baked into society. And I think at the minute that John Roberts voted to uphold the ACA, it was basically ball game over. That law was destined to become part of the American fabric, right? It could not be, unwoven or unraveled from the American system, which is why I think that these people saying, "Oh, they'll kill all of Obamacare," I think it's a fantasy. It's just not practical. It's not going to happen because it's become so important. We've now come to the point where Republicans are basically dismissing this case, saying, "Oh, this is not going to work. This is never going to happen." They don't actually want it. They bring, it's kind of like the dog that chases the car and when it gets there doesn't know what to do. That's like the Republicans on Obamacare. They just won't know what to do with it. They'll have no clue how to handle this. Which, as a common law professor, is frustrating because I think there are serious legal arguments here. They're being dismissed. They're being dismissed by people on the left who think these cases are stupid. I think they're being dismissed by people on the right because they don't want the bad politics. They don't want to have to argue, why are you ripping away grandma's health care, right? Why are you taking this person off the ventilator, right? Why are you taking a person with COVID and throwing him off his insurance? So I think the politics have, as always, taken over this case. If the court simply holds that the mandate's unconstitutional, I'll be actually happy with that because I think it's the correct ruling. I'm less concerned about severability, but I think that would be the right result. If, for whatever reason, the court goes in the opposite direction and actually strikes down parts of the statute, I think that will give a lot more juice to the court packing movement that you're reading about now. Just yesterday or this morning, a clip came out where Vice President Biden wants to appoint a commission to investigate court reform. We all know how that's going to turn out. They're going to add, or was it 30 justices, 40 justices? I forgot the right number. I don't know. I only have 10 fingers. I can't go much above 10.
I have no idea how.
Yeah, right. So, I mean, look, one of the reasons why they're pushing this court packing is to just keep pressuring the court not to rule against liberal things. That's just how things work, right? If they know John Roberts is susceptible, they can just keep putting the pressure. Judge Barrett may not be susceptible to it. I think she has a resolute backbone that Roberts never had. Maybe Kavanaugh will become the swing vote. Who knows? But I think we're going to see this pressure. 9's a good number, but 11's better. That'll be the slogan. 11's good. That's what just more seats in the bench. Everyone would just be sort of huddled together. Or you could look at Hollywood Square style tic-tac-toe grid where they're all on a game board, like in a game show. I think that'd be pretty funny. Roberts for the middle square, like the Brady Bunch. I don't know where this is headed, but I think this is a case that in our moment with the pandemic and with Justice Barrett, with court packing, there's just no way the court wants this case to be anything more than a narrow ruling that affects no one. That's where I am. Happy to hear from Earl for a bit, and we'll take some questions later. But I'm not optimistic this case goes really anywhere. Earl?
Okay, so Josh knows a lot more about this than I do. I'll just give you a couple of observations. Observation one. This is an example of a situation where Roberts tried to finesse the case the first time when it came up in Sebelius, not believing that something like this would happen, that they would reduce the tax to zero. And I don't see, frankly, even though, as Josh says, that I basically would wish that we were back to, I don't know when the court would basically defer on almost anything based on Roberts's argument in Sebelius. I don't see how an individual mandate could be constitutional if without a tax attached to it, because there's no tax attached to it right now. I don't think that. Second, again, I take Josh's point. I mean, who knows? The politics of this are completely crazy at this point. So I can see how the individual mandate would be severable from, for example, Medicaid expansion, which was another part of again, that gets complicated. We're not going to talk about the complications of it right now. I don't see how the mandate is related to Medicaid expansion, but for the reasons that Josh pointed out, it's not only the free rider issue, but by definition, if it's not just, I would describe it as slightly broader than free rider, but the bottom line is that if you don't have a mandate that works, and frankly, I don't know if Josh knows, but I'm curious if without the tax, people are following the mandate anyway. Are they?
Earl, the funny thing is the mandate was never very effective. People were ignoring it all along. And
because the tax was not, it wasn't very high. So what has happened, what will automatically happen is that the rates for everyone who is actually covered will go up, because without, this is I have to make a comment that sounds gendered, but it actually is, that it's actual reality, which is that the way that you keep insurance costs down is that you require young, healthy males to buy insurance, because because the cost to insurance companies of insuring young, healthy males is less than their cost of insuring everyone else. And if you can't get young, healthy males into the system through a mandate, the costs are going to go up automatic for everybody, almost automatically. That being said, there is this problem, and it's a classic. It's more of a political problem than a problem of actually figuring out the economics. This problem of requiring the insurance companies to insure sick, ill people who have people who are healthy pay the same insurance costs as people who are not healthy. The problem is, in political terms, that when you take away grandma's insurance, it's like, oh, look, you took away grandma's insurance. When the costs of to people who are to everyone else are diffuse, right? So in political terms, taking away the insurance or raising the rates for people who are sick is very much harder to explain than the costs associated with the mandate. Frankly, if you on this issue, this is I would describe the Obamacare situation as the classic of what's wrong with the American medical system generally, which is that we don't have a free enterprise medical system anyway, and we don't have a government-run medical system either. What we have is this sort of what we used to call a kludge, which is this mixture which just is not working very well anyway. So that's and I don't see anyone fixing that. So that's not, with respect to those things, I don't have very much to add. With respect to the issue of court packing, I actually, in order to get actual court packing, you're not only going to have the Democrats take control of the Senate. That's number one. And if anybody can tell me what's going to happen when this, particularly with the Senate on Tuesday, you win the prize. I don't think anybody knows what's going to happen with the Senate on Tuesday. But it's not only that the Democrats are going to have to take control of the Senate. I think it's very interesting that Biden keeps trying to run away from this as fast as possible. That they're going to have to take control of the Senate with basically, so let's say they had 50 or 51. Well, now you have to have, you can only get court packing if you have 51, if you don't have two senators who are saying, look, this is crazy. I understand how we got here, but this looks like Banana Republic when you start court packing, right? We don't like what the court is doing, so therefore we're going to change. Now, I understand how we got there. And for me, I could give a long discussion about this going back to, most people go back to Robert Bork. I actually go back to Earl Warren, who essentially tried to pack the court in 1968. didn't work, and that's a whole complicated situation. I'm sure that all of you want to hear about Earl Warren and Abe Fortas and Richard Nixon and all of those people. But the bottom line is we're sort of stuck right now in between. So I think getting court packing is unlikely. It is, however, the angels in the outfield rule. It could happen. And the problem is,
They don't know that movie, Abe. They've never seen that movie.
well, but I could still tell them the rule, can't I? I also tell my students the super chicken rule, and I'm the only one who knows the super chicken rule, which is you knew the job was dangerous when you took it, Fred. But so I can still tell them the rule, even if they haven't seen the movie. It could happen. And the problem is, we've been going step by step by step by step. And once you go there, I don't know where that stops, except to observe one thing. It's hard. Now, we actually talk about this at various different times. It's hard to imagine a situation. I think it's going to, well, I just don't know where we're going from there. So that in a certain sense, court packing is the logical outcome of where we've been going since, again, other people talk about other cases. I actually talk about Reynolds versus Sims and Roe versus Wade as the two benchmarks of cases which have, but it's where we've been going. And so I don't know, I just don't think it's likely to happen. I don't know if Josh has a different perspective on that, if he thinks that it's even possible that Democrats would win enough seats in the Senate to be able to get a court packing bill passed. But who knows? Who knows?
Yeah.
But as I said, go ahead.
I think it takes a few steps. The first step is to eliminate the filibuster. I think it's dead. I think okay, so step number one is eliminate the filibuster. Step number two is grant statehood to DC and Puerto Rico.
Oh, yeah, that could happen too.
Okay, then you have 4 new senators. Step number 3 is pack the lower courts. Step number 4 is modify the Supreme Court. Now, the Supreme Court expansion doesn't have to actually involve adding seats. They can do different things. And if you look at Vice President Biden was on, I think it was on 60 Minutes, he said there are other proposals. So one,
is he speaking English?
I'll let you decide. One of his proposals was to effectively create senior status. What does that mean? Once a justice serves for, let's say, 18 years, which would apply to, I think, everyone but Sotomayor, Kagan, and Kavanaugh, Gorsuch. So anyone above, say, 18 years takes senior status. And if there are any instances where there's a 9-member bench and someone recuses, we pull a senior judge to sit in on the case, which means they're basically benched. They don't do anything.
And then we have to, no, they've never required lower court judges to take senior status.
No. This would be new. It'd be a new thing. So in other words, you basically create 2 tiers of justices. So there are only 9 at any given point in time on any case, but there are more seats so that you would add 11. And if a justice recuses, you can just pull, I don't know, you can pull Clarence Thomas out from the bullpen, so to speak, and let him sit in on a case. I think that would require a constitutional amendment. I don't think you do that by statute. It's kind of perverse. All these risky ways of doing it can be invalidated by the court. The safest thing they could do would be just adding seats. But they try to tinker in any way with retirement or different panels, or maybe you have 11 justices, only 9 hear a case at a given point in time. I think the court would stop those. So you're in trouble.
Yeah. Well, so but my reaction to that is adding seats is adding seats looks is the clearest politically thing of being court packing. And that's, I think, some Democrats don't give it. Some Democrats think this is politically dangerous, but is the most politically dangerous thing. And could I put in another plug that I've sort of been talking about around something related to what Josh said about me. at the beginning.
I complimented you.
Which is, to me, this is this sort of step by step the court becoming more and more overtly politicized, and the idea of then deliberately making the court more overtly politicized is the natural outcome of the process that I referred to. So for those of you who, I'm probably the only person here who was alive in 1968, or so here's the point. All of this started, yeah, I know, 1968. We're watching the trial of Chicago 7, which I would actually sort of remember. So this is the point. So this is how all of this started. That all of this does go back to the Warren Court. And even if you say, okay, well, Brown was Brown, it's not. Brown was sort of where it started, but there were a lot of other things that weren't related to race discrimination and whatever that the Warren Court did, and that the Warren Court looked like it was going to do until this complicated process happened in 1968. I won't bore you, but we came this close, look, I'm holding up, this close to having a court that was permanently dominated by progressives, or would have been dominated by progressives in the late 20th century in the same way that it was in the mid 20th century. So the bottom line is that progressives keep looking back to that court and saying, we could still get this progressive court. The natural response of conservatives, and I'm not going to talk about when I wrote things, is and at that time, conservatives said, we basically think that because what we've seen is the Warren Court, that we think the court should defer. Well, that was never going to last as long as progressives thought that the court shouldn't defer. So now we've had this step-by-step thing, and we have, I would not describe myself as a conservative. I would describe myself as a plague on both your houses. I'm sorry, should I?
I'll pause.
A plague on both your houses person, which is we have progressives who, notwithstanding losing a lot of important decisions like Janus and things like that, very few of them, maybe Mark Tushnet, actually believe that the court should get out of the business of judicial review altogether, because that would have meant that you wouldn't have what is currently the new third rail, Obergefell. So you have progressives still longing to get back to the Warren era and not arguing for deference at all, and conservatives no longer arguing for deference. So what we have is this natural cascading effect of the over politicization of the court. Parentheses, somebody was, what was it, what did the bomb refer to? Was it polarization? Or,
yeah.
You know the book I'm talking about, right, Josh?
Yeah.
Yeah, the court became polarized. Well, what we had between 1963 and 2007 was one-way polarization, right? We had everyone who was appointed by a Democrat was a progressive justice, and for a variety of reasons. Some of the conservative Republicans weren't so conservative. But the point is, I don't know where we're going. I don't know where this stops. I don't think it is going to stop, because you're not going to, neither side is going to give up. Neither side is going to have a one-way armistice like there was in 1968 anymore. And so as a result, I think in a certain sense, court packing is the natural outcome of that.
Abe, what do you think about juris stripping? That's another proposal that Democrats are floating, that they actually either reduce the appellate jurisdiction of the Supreme Court, or even maybe tinker it such that to strike down law, you need a 6-3 vote or a 7-2 vote, right?
I don't even know what it means to say to strike down a law that you need a 6-3 vote, because here's the question. The question is, what rule of law are you going to apply? It's not whether you're going to strike down a law. It's you have a rule of law that you might otherwise have, that you would otherwise have applied, and you're going to displace that with a different rule of law. And you could describe the reason you displace that as the constitutional text or not. But so I don't even know, because I know there are some state constitutions that have it, but I'm not sure how that works. I mean, honest to gosh. Are you saying that they have to apply the rule described in the statute unless 6 judges say that in other words, I'm sorry, but you're right. I mean, one of the problems progressives face is unless they do something, because nobody talks about the election of 2008, or 2004, I'm sorry, because they lost incredibly close elections in 2004 and 2016, they have lost control of the Supreme Court for the next 20 years. So if you're a progressive and you also have a Supreme Court that, yes, John Roberts hides in cases like Sebelius, and yes, he semi-hides in the abortion case. But, cases like Janus and things like that don't have, this, or even campaign finance, they're going to constantly lose those cases. So they have to do something. I just don't know what think they can get away with.
Yeah.
I don't know. What do you think, Josh?
I think they're going to get away with adding justices. I think it's the safest way. If they try and tinker with term limits, they're going to lose, and it'll just create even more fracturing. Whenever you try and get cute and try and do things that are not straight, think of it this way: had Obama just said, "Yes, we're imposing a tax on people who don't buy insurance," Obamacare would have been fine, right? The statute would have upheld straight up. But they tried to be cute. They tried to say, "No, it's not a tax; it's a penalty that looks like a tax." But there's political cost for doing it. So if they just bite the bullet and they just make 11, there's nothing the court will do about it. It's done. It's a done deal.
Right, but so you're tough again. It has to be at least more than 50 in the Senate, because you're not going to get Joe Manchin for this. And there are a couple of other senators that and there are I think. So in this sense, Roberts is right? That they haven't overruled Roe versus Wade yet. They haven't done anything like the courts did in the early 1930s, right? It's just that they're raising the boogeyman of it might happen. And I think a lot of people, it just makes them, the idea of direct court packing makes them queasy. That on the one hand, they want to see the Supreme Court as they say that they want to preserve this myth of the Supreme Court as a non-political body. So I think court packing is politically problematic for Democrats. Now, I guess in 2 years, which could create problems for Democrats in the Senate or even in the House.
2 years is too far for me to predict. Nick, let's get some questions from students.
I was just gonna jump in on that. So the first question we have loaded up in the queue is about the prospect of DC statehood. Would that require a constitutional amendment?
All right, yeah, I mentioned, so I should take that one. It was long thought that you would need a constitutional amendment to admit DC as a state. I think those arguments have sort of faded. The Constitution says there will be a district where the central government will sit, right, where the seat of government will sit. Under the plan that passed the House, you would basically have a federal district that is the national mall. So if you've been to DC, it would basically run from the White House to the Capitol to the Supreme Court. Just that, that little federal area, that would be the federal district. And everything surrounding it would be a state. one of the weird rubs of DC statehood is that under the federal constitution, the District of Columbia gets electoral college votes, right? So there would be basically 20 or 30 people who live in that area who would have their own electoral college votes. So basically, I'm not joking. It's like a couple dozen people will be able to decide the outcome of like 3 electoral votes. No, is it Abe? Is it 2 or 3 electoral votes? I can't remember.
I think it's 3. I'm not sure.
Yeah, 3. Thank you. I'm sorry, I keep calling you Abe. I have a guy at my temple named Abe Malt, who's an old dear friend, so I always say Abe Malt. I know your name's Earl.
That was my grandfather.
Oh, well, I love that. I like it then. I'll call you Abe. So basically, you'd have 20 or 30 people deciding the outcome of the Electoral College. The bill in the Congress said, well, we'd repeal that amendment, but there's no guarantee an amendment's ever actually repealed. I think there's some constitutional vulnerability to create a state where 30 people can decide the outcome of the electoral votes. I think just there's some problems there. I think yeah. I mean that's basically like, you know, the number of people in this Zoom conference can decide 2 or 3 electoral votes. It's just insane. There's also some arguments about whether you know, the land that was given from Maryland would have to be returned. There was what's called retrocession. There are a lot of messy things, and I could actually see the Supreme Court saying you can't do it like this. You need an amendment, which is why I think you need to pack the court while you're. In other words, you add the DC statehood, then you pack the court so you have the justice to pull the DC statehood bill. You know, it's like this 2-step. He's laughing. I think it's vulnerable. I do think it's vulnerable to challenge. Just the notion that you would have 30 people casting 3 electoral votes. You know, people who are living in this federal district that doesn't really exist. Just like, you know, people have apartment buildings, you know, that touch the border. So yeah, it's a weird thing. I think smart lawyers can come up with arguments for why this is not going to work.
Well, let me just say that I can't imagine the Supreme Court holding it unconstitutional, but who knows?
It would have to be done quickly, though, because as soon as one of those senators votes for a bill, right? You know, here's the rub. Let's say the 51st vote for the court packing bill is a DC senator. So you see what I'm getting at, right? The 51st vote to pass a court packing bill is the senator. And then they challenge the constitutionality of the bill. And then the judge, I think, would have to recuse because his seat was created by that vote from the 51st senator. Oh my God, Earl's having a migraine. Right, so, you know, have at it. Go for it. I mean, you know, dumpster fire, you know, for the next 4 years.
Professor, do we have any sense of any justices on the court who might go for the sort of maximalist Texas position in the ACA lawsuit? Or do you think everyone...
Well, look, historically, you would think the really conservative justices would, but Justices Thomas and Gorsuch have signaled that they don't like severability doctrine, right? Thomas and Gorsuch have said, what business do we have to strike down statutes in their entirety? All that courts can do is issue remedies in specific cases, right? We can enjoin it, saying you can't enforce this provision as a plaintiff in this case. And Thomas and Gorsuch said, we don't strike down statutes anymore. And then you have Alito, Roberts, and Kavanaugh, who have said, no, we should be surgical. We shouldn't strike them more than what we need. So I think there are a grand total of 0 votes to strike down the entire ACA. There's 0, not 1, which is why all this fear mongering, oh, we're going to kill the ACA. It's just fear mongering. It's not real, right? It's not a real concern.
So can I make an observation about that? That if in fact that there's no showing that the mandate in fact is effective, then it seems to me it is severable. That is, that there, if it seems to me it is, because the reason my argument of it being not severable is that it has an effect on the insurance costs for everyone. But if it's not effective anyway, it's not having that effect. So
yeah, I slightly disagree. I think it does have an effect as a very small effect. The Congressional Budget Office found that for a small number of people, a mandate without a penalty will still make them buy insurance because people like following the law. It's a small number of people. Maybe it's like 30, right? But there is some minimal effect. So it does have some effect, but not 0 effect. You're basically the number of people in the new District of Columbia, 30 people, that's all you need. Can you imagine 30 people deciding 3 electoral votes? It boggles my mind. 30 people, that's it. Can you imagine how expensive those pieces of real estate would be to be one of the members? I mean, to live there, you get to basically decide if you have a close election who wins the presidency. Each person will basically be their own elector, right? Your neighbor's elector. That's it. All right.
One other question, if you have time for one more, Professor
Please,
Blackman.
of course.
So if the mandate is determined to be unconstitutional, is there anything else on the horizon regarding the ACA and Obamacare that we should be keeping our eyes peeled for into the future?
Oh, there's always ACA litigation. The contraceptive mandate never seems to go away. So we had the litigation last year with the Little Sisters of the Poor, and these groups that have opposed the mandate. The Trump administration said, okay, we're just going to excuse these religious orders and these nonprofits and even for-profits from the contraceptive mandate. The Supreme Court said, well, your policy is okay, but remand it for further consideration. So the case isn't over. If Biden wins the election, then he will probably repeal Trump's repeal of the contraceptive mandate, which means we go back to the original Obama mandate. So after 4 years of litigation, we go back to the original Obama mandate and basically start from scratch. And so I have to decide, does the Obama mandate violate the Religious Freedom Restoration Act? It's basically like the 11th circle of purgatory hell. It's called arbitrary and capricious review. You just never escape the APA. It's just you're Hotel California. You're stuck there forever. So a lot of the first, if Biden wins, a lot of the litigation will be, can Biden undo the stuff Trump did? We tried to undo the stuff Obama. So basically going back to 2008. So the last 4 years never happened. That's where we're stuck.
So can I just make one more point about the dysfunctionality of our system?
Of course.
The other thing that happens with the lower, I was just talking about the Supreme Court, talking about the lower courts is now with the lower courts are going to be deeply divided no matter what happens. Well, maybe if Trump wins, never mind. I can't imagine people's heads exploding if Trump wins again. But
sorry,
you're going. No, I mean some, not here, but you understand what I'm saying. That there are people whose heads will explode. That what we have is we have people who, with our lower courts deeply divided, and this entrenched tradition of what I describe as judicial activism or whatever. That what you have, no matter which side you're on, you go searching for the judge who shares your lower district judge who shares your ideological perspective, who then issue some nationwide injunction. It's just crazy. In other words, let me be clear, I'm not speak English. That if Biden tries to repeal undo what Trump did, then someone who's going to challenge what Biden did will search for a conservative Trump appointee to say that violated the APA and will then issue a nationwide injunction against it. I mean, its whole system is completely crazy. Did that make sense, what I just said at all in English? A little bit, or
right?
too much into the weeds.
Yeah, I got you. I think it makes some sense. I see our ranks are dwindling. We're about the size of the District of Columbia now, but 8 people left. Can you imagine how expensive that real estate is going to be? I mean, it's just you're basically buying 3 electoral votes. It's stunning to actually think the logistics.
I hadn't even thought of that. That's crazy.
Yeah. All right, Nick. Any other questions from the queue?
Doesn't look like we have any in the queue at this time. So thank you, Professor Blackman, and thank you, Professor Maltz, for your time. We really appreciate it.
Thank you so much.
Josh,
Thank you so much.
good
Thanks, everybody. Hope to see you again next year in person.
Yeah.
Thomas, I need you to ask Mr. Blackman your question.
Wow, what's your question?
Oh, Professor, I was, this is kind of not related at all, but I was just wondering if you could give me an overview of the fantasy SCOTUS and how that works, and
I will leave.
all about that, because that sounds awesome, and I've heard about it before, but I just wanted to
It's very
hear
simple.
from you.
FantasySCOTUS.net. You sign up and predict how each judges will vote in each case. It's very easy.
That's all.
Check it
That
out.
sounds great. I'm going to definitely check that out. Thank you.
Take care.